what he said, so I'm not doing that today.
Oh, and I got a family home. I know all money. I know this whole you like that. I'm pretty sure I got the date. I've been on the six.
Thursday looked like. Yes.
Pretty sure I'm down the road. I'm getting home to it. But I haven't, I've been going to all my stuff until I was ready to move.
I'm gonna put this over to Thursday.
May I say something?
No,
Mhm.
not yet, Tyler.
Yeah, you can say something.
Okay.
I did say that that I wanted to go to a rehabilitation center. But because I need help. I need help out of the streets, not just because of the alcohol or anything else. It's just something to do while in the streets. Its the main cause is the streets. I just want to get out of the streets, and I finally have a cause to get out. I have Ford Motor Company. My dad's worked there for about 30 something years, and he's willing to give me an opportunity through there. I don't know if that opportunity is going to be there still. I have to go to the local 900, and I'll even wear a tether if I have to. I need to start getting my life on task. The longer that I sit here in jail, the longer I'm doing nothing. I
Sure,
need to go.
I know how jail works.
You said, I'm sorry for disrespecting you. I'm not entirely right.
Yeah, can I see a counselor in the breakout room?
And I would still ask for a show cause just based on what he represents to me regarding his work and housing status.
He apparently has a phone.
That is true.
All right. Defendant has failed to appear and failed to pay. Bench warrant's gonna issue. Given his housing situation, I will make them low monetary bonds though.
Thank you.
1,000, 10% on each. All right, let's try this for a third time. State of Michigan versus Tyler Hagedorn, 25S00113.
What's with people?
Matthew Mansour on behalf of Mr. Hagedorn. Tyler, you know what to do.
Thank you. Mr. Mansour?
Your Honor, I have received Mr. Hagedorn's father's number. The best I can do is reach out to him and try to provide proofs that they are willing to accept his application. Because I believe he's on a list. He said his name is on the list. It's called the TPT for the local 900 list at Ford. That's the best I can do to try to provide the court documentation that he does have a job lined up. Outside of that, Your Honor, he just wants this court to consider, please just giving him a chance to test immediately. Like if we give him a personal recognizance bond, he will test upon release for drugs and alcohol. I got him to accept if the court would test him once a week for drugs and alcohol. If there's any violation, then immediate bond denied, warrant, and then check into inpatient treatment program. He's also willing to, if the court's worried about him absconding, be put on a GPS home confinement. Right now, I have an address. It's at a hotel, and he can stay at that hotel for at least a month. With I believe his sister staying there as well. I have the address as well. That's all we can request right now, Your Honor.
Thank you. Ms. West, do you want an opportunity to say anything more, or are we all set?
Judge, I just want to put on the record that I object to that request. He's failed to even check in at community corrections. He's failed to drug test even after you asked him to do it within 24 hours. He still failed to do that. And you told him if he didn't go, you'd put him in jail. I think that defendant's willing to say anything at this point just to get out of custody. And I don't believe that he would follow this court's order at all. Thank you, Judge.
Thank you. I'm gonna put this over for, like I said, to Thursday to see what proofs we have of him having any job, or if there's opportunity for him to fill out an application. I will allow him to be released to a treatment. I'll consider on Thursday, after whatever proofs we have, whether or not he can be released on a tether without going into a treatment program.
Thank you.
I'll see you on Thursday at 9, sir. State of Michigan versus Ozell Hyman, case number 25 FB 1007.
Hey, what's with people?
But I can't hear what they're saying.
All right, the court will call the matter of the state of Michigan versus Ozell Hyman, case number 25 FB 1007.
Hey, what's for the people?
Allison Muller here on behalf of Ozell Hyman. Ozell, can you go ahead and state your name?
Also, Hyman,
Mhm. We're here for a bond violation. And I think that's it, because his final settlement conference is at the end of this month on this particular matter.
Yes, Your Honor. And my request would be if we need to admit to the violation, then we can proceed. But I'm asking the court and the prosecution if we could withdraw the testing and I guess not address the violation. Mr. Hyman was facing monetary and transportation issues, which is part of the reason why we requested for him to serve the time on his other matter that was before this court. As far as the current case that's set for final settlement conference, I don't believe there are any allegations of drug or alcohol use, so I would be requesting that that part of his bond conditions be removed.
Thank you, Ms. Woods.
I'd leave it to the court's discretion.
But you do agree that there is no allegation of drugs or alcohol in this particular case?
That is correct, Judge. He was
All
just, I believe, testing for the OWI case.
And he is on another matter, or he's going to be sentenced on another matter for which he's testing?
That's correct, Judge. He has that OWI case that he hasn't been sentenced on yet.
And is that my case as well?
Judge, hold on. I believe so.
I don't know of any other matters besides the OWI that he was already sentenced on with us. I believe that the current matter that's set for final settlement conference is Mr. Hyman's only open matter.
All right, so he's serving that sentence now, and he gets out on July 25th.
Correct.
But when he gets out, he's not going to have any testing at all.
Correct, Your Honor. If that's removed, then he would not be testing. I believe the conditions are still to go back on the GPS tether. So he would be on that, which I think the original condition was not to enter Washtenaw County.
That is correct, Judge.
Mm-hmm.
And I'm sorry, the case I was referring to was the one that he is in jail for, the one where he had to self-surrender, that for that OW case. So my apologies, Judge.
Thank you. So back in March of 2025, I had ordered that he be on the GPS tether within exclusion zone of Washtenaw County and to test 3 times per month. So there had to be a reason that I ordered that. And you're telling me that he had OWI that now he just is gonna do jail time for because he didn't want probation?
Correct, Your Honor. He was having difficulties complying with the terms of his probation and made the choice at that time, given how much credit he had, to close out the matter with jail time.
That's what my notes show as well, Judge.
Right, so what that means though is he would not be testing at all, although it's clear he has a drinking problem, that's why he has OWI.
Yes,
Your Honor,
Judge.
I can go ahead, Ms. Woods, I'm sorry.
I was just gonna say, yes, Judge. So although there was no drugs or alcohol involved, from what we can see in the police report, we do believe that he has a substance abuse issue and should probably continue testing in his other matter, Judge. Thank you.
Would you like to say, Mr. Hyman? If anything, it's to your attorney, I should do that. Never mind, don't say anything unless your attorney gives you permission.
So it's up to you. I wouldn't say too much at this point, okay? But if you have something you think the court needs to know, then go ahead.
I just want you guys to know that I would like the court to know that I've been here to serve my time. I served my entire duration of my sentence for the OWI. I've been compliant. I stayed out of trouble. That's pretty much it.
Why was he having troubles complying with his OWI?
With the testing requirement?
I'm not sure what it was. That's what I'm asking you because I don't have that file in
Yeah.
front.
Your Honor, from my understanding at the time, Ozell lives with his dad, and also takes care of him. And Ozell, I believe your dad had an injury, and so you guys were kind of, you were caring for him. You don't have transportation, correct? You do rely on your dad to transport you. And Your Honor, sometimes I think it was just a monetary issue where he didn't have the funds for testing. And so him and I at one point just had a conversation. If this is going to be ongoing, you're probably going to face violations, and kind of to avoid that, didn't want him to be violated and a warrant to be issued. So we decided to proactively ask for the sentence so that he could plan and decide to turn himself in himself.
Well, I think he should be tested. So is link instead?
Well, so I would recommend to do either I would run an Soberlink because you don't have to pay up front. You won't run into those same issues. Okay. You'll keep testing until your next court date. Okay. I can talk to you further when you get out about that, but I would recommend that you do the Soberlink.
I think he wants to drink, and that's the problem.
I feel that I've already served I feel like I'm being double punished at this point. But
Right, because you have another case.
yes, Your Honor, but I'm
Two cases for which you can get 2 punishments.
yes, Your Honor, but in the other case, we weren't drinking or we weren't doing anything in that case. That was just an organic issue that had to do with drugs or alcohol. You know,
Don't say anything about that case. Ozell.
Yes, Your Honor. Yes, but
Maybe we just need to go forward with the violation for this particular case, because it sounds like he really just does not want to accept accountability for the fact that he was supposed to be testing 3 months per month on this case as well, because I reinstated the original bond, which was for him to test 3 times per month. So why don't we just deal with it that way so he feels punished?
Your Honor, we can address the violation, I understand, but I know Ozell will take accountability for not following that. And I know if the court orders the Soberlink, he will apply with that. I know his main priority is to get home and resolve these cases. And so I think that, and I can talk further when he gets out, but I know he'll come to us and I will comply with the Soberlink.
so I will comply with the silver.
It to be placed on Soberlink upon release. Final settlement conference will continue on August 29th, 2025 at 9:30. And jury selection September 5th, 2025 at 8:30. All other conditions continue, with the exception of the testing. Testing is removed at community corrections. So we'll just be doing the Soberlink only.
Thank you.
No. We'll see where we are on August 29th. Thank you. That concludes our docket today.
See you all later. See you tomorrow.
See you guys shortly. Have a good day.
Daryl Gardner.
Thank you. Mr. Gardner, you're here today for a bond violation and that you failed to appear for court on July 2025. You were arraigned by the magistrate on April 23rd of 2025. You failed to appear on two separate occasions, actually. The first one being June 9th, which was the original date that the magistrate. Nope. So originally she set it for May 19th, and then it was stipulation came in to adjourn it, and it was adjourned to June 9th. You failed to appear for that date, and then I rescheduled it for July 7th, and you have failed to appear for that date. As I indicated earlier, this is a 2013 case. Ms. Moulton.
Thank you. I spoke with Mr. Gardner regarding the failure to appears. I don't believe he knew about received the date for the first date. I think I have the dates that we went into detail about was the 7th and the 16th. He was at work on the 7th, lost track of time. He immediately called in, and that's when he was rescheduled.
Came in. I went to 72.
Oh yeah, you said you had your you had your work clothes on and everything, and they gave him the new date. He sat in the court. He said he was there for about 4 hours. I believe he was last Wednesday. I actually am assigned to that court, and I can confirm that date went very, very long. So I'm not sure what happened. They bring everyone in one by one. Not sure why his case wasn't called at the time. However, he has been trying to address this case. We're trying to figure out what is left so he can get it resolved. He just paid to get his car out of the impound, and then now it's back there after he got arrested this weekend. So he just does not have the money to pay a monetary bond. He's gainfully employed. He's seriously trying to resolve this case. So we're just trying to figure out what's left and a personal bond so he can return.
I'm not certain what you're referring to with respect to the fact that he was in court on any given day. The last notice in this file is from July 7th, unless you point out where I'm missing something.
July 16th, he was rescheduled for that day after he missed the prior hearing that he missed due to work.
You see that in JIS, man? July 16th date. Was he there for 4 hours? A long time. Can you give me a Wednesday date, please? The next available, not extremely busy Wednesday date. That's the first available with not many.
It's the first available months. There's also August 13th when that is.
Court day will be on August 27th, 2025 at 9:00 a.m. I'm going to reinstate a personal recognizance bond. The main reason I'm doing it is because this is a 2013 case, and I'm not sure that they'll be able to proceed on it. Sir, if you miss another court date, then what's going to happen is you're going to just end up sitting in custody until we finalize the matter. Are we clear?
Yes, ma'am. I didn't miss it. I did miss it. I did miss it, but in my defense, June 9th is my birthday. If they would have told me I had court on my birthday, Your Honor, I would have remembered it. I was never notified of a June 9th hearing. So that's how that court date was quote unquote missed. If they would have told me on my mother's grave, I would have appeared. Because it's a day of celebration. It's my birthday. I would have remembered it. So I promise you, I will show up. I will show up for any court date you schedule me for. Anyone.
All right, what court date did I just give you, sir?
Huh?
What court date did I just give you?
August 25th, I believe.
August 27th, sir,
27th. Okay.
on Zoom. And you need to stay in the room until your case is called.
All right. Yes, ma'am.
All right. I will reinstate the personal recognizance bond. See you on that particular date. All the other conditions are reinstated.
Thank you.
You're
Thank you.
welcome. That's before me, so I'll remember if you don't show up.
Yes, ma'am.
All
I'll
right.
be there.
You're all set, sir. Have a good day.
Okay, thank you.
You're welcome.
You can go around that way, sir, if you want. Jeff.
What's your name, sir? What's your name, sir?
Shaka.
Roll call the matter of the state of Michigan versus Shaka Khan, case number 25S00039.
Ashley Moulton on behalf of Mr. Khan. State your name, sir.
Shaka on the record.
Thank you. All right, we're here for a bench warrant. A bench warrant was issued by me in this case because Mr. Khan failed to test at all on July 1st, 2025. And he had police contact of some sort.
Yes, regarding the police contact, he was pulled over for a traffic violation, no proof of insurance and expired tags. He was driving someone else's car, and the insurance has been updated and the tags there's a appointment scheduled for tomorrow for the tags to be renewed. And regarding the missed test and the one late test that was negative, he honestly does not recall. He does have some medical issues that causes memory loss. He does not know why or how he missed those tests because he has been working to be compliant with that. We are requesting that he receives a personal bond today. He has no issues moving forward complying with his previous conditions.
May I ask if I could honestly get an alcohol tether?
Instead of the Soberlink?
Yes.
Okay, one moment.
That hearing had a little bit of everything. In this wide-ranging docket, we followed multiple defendants, each at very different points in their legal journeys, but all navigating bond violations, testing requirements, and in some cases, long overdue resolutions. What stood out wasn't just the mix of offenses or defenses, but the courtroom's tone, direct, at times sympathetic, and very often layered with accountability. Judge wasn't there to scold or grandstand just to make sure everyone heard the terms loud and clear. Let's start with Tyler Hagedorn, whose bond status remains in limbo. He spoke sincerely, saying he wants out of jail not just to avoid sitting idle, but to turn his life around with a job opportunity at Ford Motor Company, no less. His defense attorney tried everything, proposed testing on release, GPS tethering, inpatient treatment, and even staying at a hotel with his sister, but the judge wasn't biting, at least not yet. Given Tyler's history of missed check-ins and ignored court-ordered testing, the court wants to see actual proof of that job offer before granting anything, hearing pushed to Thursday. Real stakes, but real chances. 2. Then came Ozell Hyman. His situation's a bit more nuanced. He'd served time for an OWI and was under order to test 3 times a month on another matter. Now, Out defense tried to argue there were no new drug or alcohol concerns in the current case, so the testing requirement should be dropped. The judge, however, remembered exactly why testing was ordered back in March. A drinking problem was clearly part of the story. Ultimately, the judge softened the approach, removing the prior testing condition in favor of a Soberlink setup upon release. It's accountability without financial barriers, but the court made it clear Ozell has to stay on track, and everyone's watching. Next up, Gerald Gardner. This one had a touch of comedy, if not for the underlying stress. He'd missed multiple court dates, but claimed sincerely that he'd been trying to show up. At one point, he sat in court for 4 hours and still wasn't called. The judge, faced with a 2013 case that might not even hold up anymore, reinstated a personal bond and gave him one more shot. Gardner promised to show up and even joked that if court had been scheduled on his birthday, he'd have remembered. The judge reminded him she'd remember too if he didn't. Finally, we heard from Shaka Khan. He'd missed a drug test and had a recent traffic stop for expired tags and no proof of insurance driving someone else's car. He blamed medical memory issues for the missed test and asked for a switch from Soberlink to an alcohol tether. Nothing explosive, but a good example of how judges weigh past compliance against present promises and how defense attorneys tailor asks just enough to address a judge's known concerns. Altogether, this docket showcased the grind of criminal court, where technical violations carry weight, but context still matters. The judge was firm but not cold, probing for proof when needed and offering paths forward when deserved. That's how trust and structure meet in a courtroom. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.